Just may find here the notice is issued on 23rd of May 2023, which is on page number 19. There are around 100 such notices. In present case, there are 10 petitioners and we have annexed only one for your Lordship's perusal. I have copy of all the notices. I did not, if Lordships have the notice on page 19, the original copy is also very much legible. It is under section 216(2) bracket 1 of the GPMC Act and the Town Planning Act. Lordship, I may just read. Some stereotype notices to all. ઉપરોક્ત વિષય અન્વયે આપશ્રી દ્વારા તથા જીપીએમસી એક્ટ ની કલમ 253, 54 તથા ગુજરાત સરકારશ્રી દ્વારા ધી ટાઉન પ્લાનિંગ એન્ડ અર્બન ડેવલપમેન્ટ એક્ટ 1976 અન્વયના CGDCR ની જોગવાઈઓ વિરુદ્ધ મહાનગરપાલિકા મંજૂરી મેળવ્યા વગર મંજૂર થયેલ બિલ્ડિંગ પ્લાન વિરુદ્ધ ભાવનગર મહાનગરપાલિકા પ્રવર્તમાન નિયમો વિરુદ્ધ ગેરકાયદેસર રીતે દર્શાવેલ વિગતે બાંધકામ શરૂ કરાવેલ છે. બાંધકામની વિગત ગ્રાઉન્ડ ફ્લોર પર પતરાનું બાંધકામ. Lordship may just note that. તથા માલિકીના આધારો તથા બાંધકામના આધારો દિન 2 માં રજૂ કરવામાં રાખશો. Lordship, the printed part is also important. ઉપરોક્ત હકીકતે આ બાંધકામ ભાવનગર નગરપાલિકાની મંજૂરી વગરનું નિયમો અને કાયદા વિરુદ્ધ હોવાથી આ નોટિસ મળેથી તાત્કાલિક બંધ કરી દેવાનું રાખશો. તેમજ આ કાયદેસર બાંધકામ બાબતે દિવસ 7 માં જરૂરી આધાર પુરાવો સાથે ભાવનગર મહાનગરપાલિકા બિલ્ડિંગ પ્લાન મંજૂર કરાવી લેવા અંગેની કાર્યવાહી હાથ ધરવી. જરૂરી આધાર પુરાવો રજૂ કરવા જરૂરી સ્પષ્ટતા દિવસ 7 માં રજૂ કરવાની રહે છે. જો આ બાંધકામના બિલ્ડિંગ પ્લાન મંજૂર કરાવેલ હોય તો તે અંગેની જરૂર આધાર પુરાવા આ નોટિસ મળ્યાથી દિવસ 2 માં રજૂ કરવાના રહેશે. આ બાબતે આપના તરફથી દિવસ 7 માં જરૂરી સ્પષ્ટતાઓ આધાર પુરાવો જવાબ વગેરે રજૂ નહીં થાય તો ભાવનગર નગરપાલિકા દ્વારા આ ગેરકાયદેસર બાંધકામ ધી જીપીએમસી એક્ટ 1949 ની કલમ 262 અનુસાર આપના ખર્ચ અને જોખમે દૂર કરવામાં તેમનું હશે. Now this is the notice. Now this notice was replied, Lordship, because it was, we had to rush, all the people have to rush and they had to reply. I may just take your Lordship through the documents. Lordship may have page 21. Page 21 is the BPL card of the petitioner. Then page 22 is the map station. Lordship may have page 24. This area is a slum, a declared slum, and these persons have been issued the identification that you are occupying this slum. Lordship may just find page 24 on top. 1983 પહેલા. Lordship find that on the left hand side on top. 1983 પહેલા. So ઝૂંપડાવાસીનું ઓળખપત્ર ભાવનગર નગરપાલિકા. So it is issued by the respondent નગરપાલિકા. It records that it is the occupant is residing there prior to 1983. Lordship, I have similar occupation cards for several other people. Now Lordship may just note, if your Lordship just see કેટલા column number 7 કેટલા વર્ષથી વસાવટ કરે છે? 14 વર્ષથી ઝૂંપડપટ્ટી. And this is issued on, Lordship will find left hand side bottom, it is 3/5/1991. Lordship find that left hand side bottom, it is issued in left hand side. And ઝૂંપડાનું number 5, that is also mentioned there, right hand side. Just serial number 10, ઝૂંપડપટ્ટીના વિસ્તારનું નામ મસ્જિદ પાસે 14 નાળા ઘોઘા રોડ, વોર્ડ ઘોઘા રોડ 19, ઝૂંપડા number 5. And the family members are mentioned on page 25. So Lordships, this is known to be a slum. The petitioner has been issued an identification by the Nagarpalika. Page 26 is the assessment, taxes being paid by the petitioner and other such occupants. Now, this is all submitted. We anyhow tried to manage whatever we could collect within 2 days and submitted to the authority by a reply, by written submission, which your Lordships will find on page number 35. This is the receipt. The receipt is also given by the Nagarpalika. This is given on 35, and this is the submission given to the authority. Now, Lordships, may just see the document at page number 30. It starts from 29. It's a sum declaration. It's I just want to bring show to you Lordship the original and then read the if Lordship is page 30 when it is signed by all the authorities. So it is just to authenticate this document before your Lordships. I have put this original one because it is not readable. If Lordships have page number 33A, slum of department, Bhavnagar, it's slum department, Bhavnagar Municipal Corporation slum list, September 2014. Lordships may have serial number 84 and 87 on page numbers 33F. Serial number 84. Am I with your Lordships? Kansara no Kato, opposite Rajaram Avedo, Goga Road, ward number 3, BMC, Bhavnagar Municipal Corporation. Over the Lordships may come to page 33G, 87, Bethel Nalu, Sardar Nagar to Shivaji Circle Road, both side Kansara Kate, there, ward number there, BMC private. Now, Lordship, these are the documents we could submit to them. Lordship, page 20. The order. On 23, the notices are issued, and on 26, we submitted reply. And page 20, they passed the order. And this is a serious psychosocial order given to all. No reasons. What is the reason to reject? What are the circumstances? Why? Lordship, this is under, if Lordship is subject, Vishay. GPMC Act ની કલમ 262 અન્વયે નિયમ વિરુદ્ધ તથા ગેરકાયદેસર બાંધકામ દૂર કરવા બાબત સંદર્ભ ટાઉન Lordship may just that notice is referred to. I may just read. ઉપરોક્ત વિષય સંદર્ભે ભાવનગર મહાનગરપાલિકા વિસ્તારના મફતનગર રાજારામનો અવેડો વાળો ખાંચો ભાવનગર ભાવનગર મહાનગરપાલિકાની માલિકીના લીઝ હોલ્ડ પ્લોટ રસ્તા પૈકીમાં જે બાંધકામ કરેલ છે તે બાંધકામના પ્લાન શ્રી GDCR ની જોગવાઈ મુજબ મંજૂર કરાવેલ નથી તથા બાંધકામ શ્રી GDCR ની જોગવાઈ વિરુદ્ધ કરેલ છે તેમજ જમીનની માલિકી બાબત પણ કોઈ યોગ્ય આધારો રજૂ કરાયેલ નથી આ બાંધકામ GPMC એક્ટ મુજબ નથી તથા ગુજરાત ટાઉન પ્લાનિંગ એન્ડ અર્બન ડેવલપમેન્ટ એક્ટ 1976 હેઠળના સરકારશ્રી દ્વારા મંજૂર કરેલ CGDCR 2017 ની જોગવાઈ વિરુદ્ધનું માલુમ પડેલ છે અનધિકૃત બાંધકામ બાબતે અત્રેથી GPMC કલમ 261 મુજબની નોટિસ આપવામાં આવેલ છે આ નોટિસ અન્વયે આપશ્રી દ્વારા સંદર્ભ 2 થી કરવામાં આવેલ રજૂઆત ગ્રાહ્ય રાખવામાં આવેલ નથી આમ આ બાંધકામ પર્વતના નિયમ અને કાયદા વિરુદ્ધ છે તેથી નીચે મુજબ હુકમ કરવામાં આવે છે હુકમ ઉપરોક્ત હકીકતે આ બાંધકામ ભાવનગર મહાનગરપાલિકાની મંજૂરી વગર તેમજ પર્વતમાન CDGCR ની જોગવાઈ વિરુદ્ધ કરેલ છે તેથી આ બાંધકામ અનધિકૃત રીતે કરેલ હોવાનું સ્પષ્ટ થતું હોવાથી આ અનધિકૃત બાંધકામ GPX ની કલમ 262 મુજબ આપના ખર્ચે અને જોખમ તોડી પાડવા આથી હુકમ કરવામાં આવે છે. Now, Lordship, this is the psychosocial order given to all. Lordship may just see section 260 of the GPMC Act because that would require that at least they may consider the reply, pass a reasoned order, and then proceed with demolition. Here, within 2 days. The orders are passed. Lordship, sir, section.
Yes.
Section 260, proceedings to be taken in respect of building or work commenced contrary to rules or bylaws. If erection of any building or execution of any such work as is described in section 254 is commenced or carried out contrary to the provisions of rules or bylaws, the commissioner, unless he deems it necessary to take proceedings in respect of such building or work under section 264 shall, by written notice, require the person who is erecting such building or executing such work or has erected such building or executed such work on or before such day as shall be prescribed in such notice by a statement in writing subscribed by him or by an agent duly authorized by him in that behalf and addressed to the commissioner to show sufficient cause why such building or work shall not be removed, altered, pulled down, or B, shall require the said person on such day and at such time and place as such be specified in such notice to attend personally or by any agent duly authorized by him in that behalf and show sufficient cause why such building or work shall not be removed, altered, or pulled down. If such person shall fail to show cause to the satisfaction of the commissioner why such building or work shall not be removed, altered, or pulled down, the commissioner may remove, alter, or pull down the building or work and expenses thereof shall be paid by the said person. Now, Lordships, this process, now, Lordship, this has to be taken by the commissioner. Now, Lordship, there's one judgment of Honorable Supreme Court with respect to Mumbai, because the act was Mumbai, earlier known as Bombay Municipal Corporation Act, now it is known as Gujarati. The sections are almost same. I would not say pari-material, but almost same. And the earlier act which was applicable to the Mumbai was Mumbai Municipal Corporation Act 1883. In this context, the Honorable Supreme Court has said that there has to be a period of at least 7 days of notice and 15 days after the order. Lordship may just consider this judgment. If I may just invite your Lordship's attention to first para 3 on page 785, what the High Court had decided, so that Lordship, the issue would be clear. Para 3, page 785. Before we refer to the statutory provisions, we may make reference to the judgment of the Bombay High Court, which appears to be locus calcilicus on this subject as far as the Bombay High Court is concerned. In Sopan Maruti Thopte versus so-and-so, the Bombay High Court referred to various provisions and thereafter issued following directions. Directions are images. Hence, on the basis of the law as discussed above, it is directed that after 1/5/1996, the Bombay Municipal Corporation or Municipal Corporation constituted in the BPMC Act would follow the following procedure before taking action under Section 351 of the BMC Act or under Section 260 of the BPMC Act, same section. In every case where a notice under Section 351 of BMC Act, under Section 260 of the BPMC Act is issued to a party, 15 days time shall be given for submitting the reply. In case the party to whom notice is issued sends the reply with documents and shows cause, the municipal commissioner or deputy municipal commissioner shall consider the reply, and if no sufficient cause is shown, give short reasons for not accepting the contention of the affected party. It would be open to the commissioner to demolish the offending structure 15 days after the order of the commissioner. Deputy municipal commissioners communicated to the affected person. In case the staff of corporation detects the buildings which is in process of being constructed and or extended without valid permission from corporation, it will be open to the commissioner to demolish the same by giving a short notice of 24 hours after drawing a panchnama at the site, and also by taking photographs of such structure and or extension. The photograph should indicate the date when the same are taken. In case where the municipal corporation has followed due process of law and demolished the unauthorized structure and or extension if the same is reconstructed without valid permission within the period of 1 year, it would also be open to the corporation to demolish the same by giving a short notice of 24 hours. If the offending structure and or extension which is assessed by the corporation for 2 years, Lordship, the assessment is also taken care of. Notice shall provide for 15 days time to show cause. If the deputy commissioner comes to the conclusion that he requires assistance of the party, he may give an oral hearing if he deems fit and proper before passing the order. It is made clear the oral hearing is not at all compulsory, but is at the discretion of the authority. In any other case, the corporation is directed to issue a show cause notice in case of any structure or extension other than those mentioned in clauses 1 to 4 above. The corporation shall provide for 7 days time to show cause in such case. Now, Lordships, in this context, Lordships may just take note, because in Maharashtra, the legislature, Lordship may have page 790 para 10. Para 10. Because the legislature amended and gave 15 days time to 7 days. At this juncture, it would be necessary to point out that when Sopan case was decided, there was no provision fixing a timeline for filing a reply to such notice. Now 7 days has been fixed to file the reply in terms of Section 350 of Section 1A, and therefore the first direction in Sopan is no longer operative. The legislature enacted a provision in this direction cannot be said to be valid anymore. Lordship may just note in the printed form, there are 7 days. If Lordship just sees the notice on page, the printed form says 7 days. It is almost similar to that. Page 19, if your Lordship sees the printed. ઉપરોક્ત હકીકત આ બાંધકામ નગરપાલિકા મંજૂર નિયમો અને કાયદા વિરુદ્ધ હોવાથી આ નોટિસ મળે તાત્કાલિક બંધ કરી દેવાના રાખશો અને બાંધકામ બાબતે દિવસ 7 માં જરૂરી આધાર પુરાવો. Lordships may just make note of that.
Notice,
Lordships?
yes.
Notice page 19. The printed form includes 7 days time.
Yes.
But by hand written they say दिवस 2 बार रजू करो. So what is stated by Honorable Supreme Court is now in my humble submission to a large extent incorporated. Now, Lordships, in this context, Lordships may have para 13. Para 13. However, as pointed out by Mr. Javeri, learned counsel appearing on behalf of the respondent, the second direction Sopan case requiring 15 days notice to be given to the affected person before demolition of the structure is still valid, and therefore 2 notices are required to be given, namely show cause notice of 7 days in terms of section 351(1)(a) and notice of 15 days in terms of Sopan case. The learned counsel also submits that the judgment in Sopan case hold the field till date, and we agree with the counsel that in terms of demolition direction 2 in Sopan case, 15 days notice has to be given before demolishing the structure. We are not oblivious to the fact that subsection 2 of section 351 does not lay down any timeline in this regard. It was in this context that when 2 timelines were laid down either for show cause notice or for demolition, that the Bombay High Court in Sopan case fixed 2 timelines of 15 days each for issuing show cause notice and thereafter to take action of demolition. The legislature intervened and first period has been curtailed from 15 days to 7 days, but the second direction has not been interfered with by the legislature. Therefore, the judgment continues to hold the field in this regard. Admittedly, in both the cases, the second notice does not comply with the direction given in Sopan case. Therefore, there is no manner of doubt that the requirement with regard to second notice has not been complied with in either of the cases. As such, the action of demolition without following the procedure prescribed by law is illegal. So, Lordship, this is what the Honorable Supreme Court said with respect to Maharashtra Act. Well, also, there's one more judgment with respect to such notice and giving the proper time to take action. Lordship, that is 2019 6 SCC, page 150. There, the High Court struck down the notices. The Cantonment Board went to the Supreme Court, challenging that such notices could not have been, the High Court was not correct in quashing such notices. Lordships may have in para 2, Lordships will find, in writ petitions filed before the High Court, respondent original petitioners had prayed for quashing of notices issued by the appellants under section 185 of the Cantonment Act 1924, so for stopping the alleged construction raised unauthorizedly by the respondent original petitioners, as well as for quashing of the notice issued for demolition of construction so raised. The respondent writ petitioners have also prayed for quashing of the appellate order passed by the appellate authority, dismissing the appeals preferred by them. Lordship, just come down to the bottom of that page and just see the notice. It's almost same. Subject show cause notice. It has been reported to me that you have carried out following unauthorized construction without prior permission in shop number so and so, the address. Now, in this context, Lordships may have para 7. Another ground before the High Court was that the notice were issued in casual manner, and in spite of submitting the reply to the show cause notices, the primary authority has not considered the replies and passed order, and even appellate authority has passed stereotype orders without giving any opportunity and fixing the date of hearing. First 2 grounds raised by the respondent writ petitioner were not accepted, but however, High Court has held that the reply filed by the respondent original petitioners was not considered and no reasons were assigned for rejecting objections. Further, it is also held that the appellate authority passed orders which are more or less identical and passed in predetermined manner without giving any opportunity of hearing. While quashing the impugned order, the High Court, by the impugned order dated so in 1912-2013, left open to the appellants to proceed afresh in light of the observation made in the judgment. So this was what has been said. Now, Lordship, in this context, Lordship, may page 12. Para 12, next page 153. At the outset, it is to be noticed that agreed by the common order passed by the High Court, Cantonment Board and others have filed appeals, and there are no appeals filed by the respondents in agreed by any of the findings recorded in common impugned order. The jurisdiction questioned by the respondents and the authority of the appellants in issuing notice under section 185 of 1924 Act is rejected by the High Court. Similarly, further plea of not taking action within period of 12 months from the date of construction also rejected by the recording reason. We do not find any error on such findings recorded by High Court, more particularly absence of any appeal preferred by the respondent on digital petition. At the same time, we are of the view Valid and cogent reasons are recorded by the High Court for quashing the notices under Section 185 of 1924 Act and ordered by the appellate authority. Apart from reasons assigned in the impugned order, we have also verified the other material placed on record. So far as Afzal, who is responded in civil appeal number so and so is concerned, show cause notice dated 22/8/2000 is issued, alleging that he has constructed shop number so and so, but the same is not even referred to in final notice dated 2/9/2006. It is the case of the respondent that objections were filed and their objections were also not considered. Having issued show cause notice, the primary authority ought to have referred to such notice and objections, if any, to such notice while issuing final notice on 2/9/2006. It is clear that notices are issued mechanically and in casual manner. Even the appellate authority, relying upon the survey report dated so and so, has held that the respondent in civil appeal has raised unauthorized constructions on the first floor of shop without taking any permission of the complainant. Further, it is stated that such survey inspection report is not furnished to the respondents at any point of time, though such report is relied on for rejecting the appeal preferred by the respondent. So, Lordship, the Honorable Supreme Court upheld the quashing of notices and said that further notices can be issued and actions can be taken. Now, there is one order of the Supreme Court with respect to Haldwani demolition, where the railway land was occupied, and it was held that the people have been occupying railway land and there are hutments. 7 days time was given by the High Court to remove the entire hutment. The Honorable Supreme Court stayed that. Lordship, may have page 3 of the order. Page 3, Lordships may have. Bottom paragraph, apart from that, of that order. Apart from that, there are issues of occupants claiming rights in the land as lessee, auction purchaser. We have cavilled to the way the directions have been passed in impugned order, as there cannot be uprooting of 50,000 people overnight within 7 days. We do believe that workable arrangement is necessary to segregate people who may have no rights in the land and those who have put but to be removed, but coupled with schemes of rehabilitation which may already exist, while recognizing the need of the railway. We have put to learned ASG that look may be had to the methodology of achieving the purpose of requisite land being made available to the railways, coupled with the rehabilitation of persons in the area. In pursuit of the earlier Supreme Court orders, proceedings under the Public Premises Act have been taken up and culminated, or some appeals are stated to be pending but without stay. Those proceedings will issue notice, learned ASC so and so, last part. In the meantime, there shall be stay on the directions passed in the impugned order. That has to be coupled with a complete restraint on any further occupation of land and or a construction, whether by existing occupants or by anyone else. So, Lordship, in my humble submission, this is a slum declared by the Nagar Palika. Therefore, it would be protected under the Gujarat Slum Clearance Act, because if the slum is to be cleared, the procedure under the slum.
That is not the notice, no? It says
that is not notice. That is not the notice.
So this judgment is when you are completely being uprooted from there. So that is not there.
Because
what does the notice say?
That is to be removed. Then what will remain there? If my structure is entire structure, if the authority removes the entire structure, what remains there? I cannot live without a shed or roof. They say entire bandhkam. And so, Lordship, what they say is that, and they don't say, that is one of the issues. I am obliged to a Lordship, that they don't even say that this is illegal occupation of some government land or some land, and therefore you are illegal occupant. That is also not said. Only allegation is with respect to the construction. Now, if it is construction, Lordships are aware, the constructions can be regularized. These are hutments. They are not big buildings or apartments or bungalows. They are small people who have constructed, and they have been there since prior to 1983. Now, if at all they find that there is some illegality in construction because they had not taken permission, Lordship, that under the Gujarat Regulation of Urban Development Act, which is 2022, which has now come into force, or any other provisions which are there in GDCR and Town Planning Act, this can be regularized. But to immediately demolish it, saying that तात्कालिक असर भी हमें दूर करवा वहां से, the roof goes, the shelter goes for all these people, and that too without considering reply and within 2 days. Notice is of 23rd of May, the order is of 26th of May. That is on,
Yes.
your lordship just,
Advance notice has been, advance copy has been served.
But the considered authority would be the municipal corporation. This one number 2 and number 3. I cannot get the number, but
Yes.
number 3 will be represented by a separate catalog.
Anybody is regularly appearing for them?
Leonard Finn was,
You can serve a copy tomorrow.
please, your lordship, I'll do that.
No, notice can be for both.
For both, town planning down band officer is also officer of the,
Tomorrow,
I'll take that, yes.
direct sir.
Please, your lordship.
And I know.
Yes.